All right, buckle up because what you're about to watch is one of the most jaw-dropping courtroom moments we've covered on this channel. A woman named Brittany Abbott walks into a Michigan courtroom expecting a sweetheart deal, 6 months of a delayed sentence, meaning if she behaves herself, the whole thing just disappears. Sounds pretty good, right? There's just one small problem. The judge isn't buying it. Not even a little bit. Here's what happened. Brittany Abbott worked as a process server. That's the person whose entire job is to physically hand legal documents to defendants so they know they're being sued. Simple enough. But instead of actually serving people, she allegedly just filed paperwork with the court saying she did. She even described one person's physical appearance, including a missing ear in her proof of service. A missing ear. That's not a random detail. That's the kind of specific lie that makes this case go from workplace mistake to what were you thinking? Two real people, real citizens with real legal rights had lawsuits filed against them and never knew. They couldn't defend themselves. They couldn't show up to court because of one process server with a phone app and zero accountability. This isn't just a paperwork error. This is a direct attack on the foundational right of due process. Today's sentencing hearing was supposed to be a formality. Her lawyer had a deal. The prosecutor accepted it. But the judge had other plans. Stay with us, because this gets wild fast.
And Mr. Kukuski, we can call your case.
Thank you, Your Honor.
People be Brittany Abbott. I'm here for sentencing on a charge of evidence tampering. It's a 4-year statutory maximum and a guideline range at 0 to 9 months. All right, Mr. Kukuski, anything you want to say on your client's behalf?
Well, Your Honor, I'd just say that I believe Ms. Abbott's going to be successful on the term of delay and the agreement that we've worked out with the prosecutor. It's an interesting case to me in that she gets hired on or is hired on for some firms that are collecting credit card debts, and she's to serve people. And there's not really much training as to how that service is to be done. I think she now understands the ramifications of what had happened. She has expressed to me she's very apologetic to the victims in this case, and sorry that if anything happened with their case, that she's sorry about that. But she did. It wasn't that she just mailed it in, Your Honor, where she said she served somebody, but she didn't. She did drive down from Marquette, go to these residents. Although somebody at the residence that she serves, it's not the right person. So again, I think the disposition that's been worked out here is addresses the issues and addresses the conduct and behavior. I would ask the court to follow the agreement that we have for the 6-month delay with Ms. Abbott at this time. Thank you.
Okay, let's pause here and break down exactly what just happened. The defense attorney is presenting this case as a training problem, basically arguing that Brittany Abbott didn't fully understand what her job required. But wait, she's a process server. The entire job is to hand documents to a specific person and confirm it. That's it. That's the whole gig. And yet, the attorney is asking for a deferred sentence, meaning 6 months of good behavior and the case gets wiped clean. No jail time, no felony record, nothing. The guidelines supported 0 to 9 months, and the prosecutor already agreed. On paper, this looks like an easy sentencing hearing. But notice the judge hasn't said a word yet. That's silence. That's the calm before the storm. The judge is clearly thinking, and the defense attorney might not like where this is going.
Well, I wonder about those facts. She filed a proof of service with the court indicating that she had personally served the named people at an address and the location and included a description of the person, including, it said for one of them, described his appearance, including having a missing ear. So that sure sounds like Miss Abbott is intentionally trying to say, yes, I personally served this named person when she didn't, and not just some sort of technical mistake that she didn't know she could leave it with someone else at the household. So help me square that circle.
Well, Your Honor, there's an application with these firms that she's working with where you just check the box when the paper's delivered. They do the proof of service to the court. And that's the proof of service that was provided to the court. She was not personally taking those to the court. again, she accepts her responsibility for the improper service. We're definitely not making any excuses there. It just, I want Your Honor
The proof of service is signed by her, right?
it would be electronically on her phone through the application with the company that she has. And so again, as I've stated, she's learned from this. She understands, even if anybody else was not proper, but it could have been where you just check the app that you did it, and you didn't even leave your home or come down to try to affect service. And she's accepted the responsibility by entering into this delay that she knows that it was not proper. And we're not making any excuses here, Your Honor.
This is the moment the entire hearing pivots. The judge zeroes in on one devastating detail. Brittany Abbott didn't just check a box, she described the person she allegedly served, including A, missing, ear. Let that sink in. You can't accidentally write that level of detail about someone you never met. That's not a clerical error. That's fabrication. That's invention. That's a lie dressed up as sworn legal testimony. And watch how the defense attorney tries to spin it suddenly. It's all about the app, the company's software, how it auto-generates forms. But the judge isn't having it. The proof of service is signed by her, right? That one question demolishes the entire "I didn't know what I was doing" defense. Whether it was electronic or paper, her name is on it. Her certification, her oath. This is the moment you can feel the momentum shift in that courtroom. Think the judge will accept the plea deal after this? Drop your prediction in the comments.
Well, I'm wondering whether she should get a delay, honestly. So I'm wondering a process server that intentionally falsifies a proof of service with a court. That's what she's convicted of.
Yeah.
Somebody that does that, in my mind, ought to go to jail. So that's what I'm thinking about.
Well, Your Honor, I don't believe this is the case that would warrant that. I definitely understand the court's concern. I do. But I'm not trying to make any excuse for the client. No.
All right, I can tell you there's no way I'm doing a delay. All right, Ms. Abbott, you don't have to make a statement today. Is there anything you want to say or no?
I can tell you there's no way I'm doing a delay. 5 words. 5 words that just blew up months of negotiation between the defense and the prosecution. The plea agreement, the one both sides agreed to, the one the guidelines support, is dead on arrival. The judge isn't just skeptical, he's outright rejecting it. And here's why that matters legally. In Michigan, and in most U.S. jurisdictions, a judge is not obligated to accept a plea agreement. They can hear it, review it, and reject it entirely if they believe justice won't be served. This judge clearly believes that a deferred sentence for intentionally lying to a court in writing with fabricated physical descriptions is not justice. It's a slap on the wrist for a crime that stripped 2 people of their constitutional right to notice and a fair hearing. The defense attorney looks stunned. The defendant hasn't even spoken yet, and it's about to get worse.
Yes, I would like to sincerely apologize for being completely negligent.
See, okay, okay, hang on. You're not convicted of being negligent. Now, you pled no contest, so I can't force you to make a statement about this. But I'm not going to sit here and let you... You're convicted of intentionally tampering with evidence. You're not convicted of negligence. So let's start again.
I was incredibly naive, and I did not understand how to do my job at all. I didn't understand how to be a process server. So I just want to say.
All right. Ms. Goodrich, any recommendations from the people?
Yes, Sharon, thank you. Here as stated, 2 victims had come forward on June 4th of 2025 to report perjury complaints stating that there was proof of service filed with the district court where they were not served. Fortunately, they both were able to prove that they were at work at the time. What's confusing about the explanation here today is that the explanation that the defendant has given is that she handed it to someone else, but that's not in the PSI description of the offense. And in fact, it says that neither of the people had cameras at their house to see if a process server was at their residence. So it'd be strange that nobody at their house would tell them, hey, I got this paperwork here today, if somebody else was actually served. So I would guess that no person was served at either household based on those set of facts. The defendant is 36 years old. She has no prior felonies and one prior misdemeanor. Looks like she's part-time or sporadically employed and has a bachelor's degree. The guidelines are 0 to 9. The plea agreement was for the 6-month delay. The PSI accepts that with a focus on services being for mental health treatment for the defendant, as well as using her positive family support system more so that she makes better decisions in the future.
All right, thank you. Ms. Abbott, if you please stand for the first sentence.
Did you catch that? Brittany Abbott opens her mouth to apologize and immediately says she was completely negligent, and the judge stops her cold. Because negligence and intentional conduct are two completely different legal categories, and the difference between them can mean the difference between a misdemeanor and a felony, between probation and prison. Negligence means you made a careless mistake. Intentional conduct means you chose to do something wrong. She pled no contest to intentional evidence tampering. That means by her own plea, she is acknowledging conduct that goes beyond a simple mistake. And now she's standing in court trying to walk it back as naivety? Meanwhile, the prosecutor drops the other shoe. The victims had alibis. They were at work. Nobody at either house mentioned receiving any paperwork. The defense attorney's "she handed it to someone else" story, it doesn't match the pre-sentence investigation report. The story keeps shifting, and the judge is tracking every contradiction.
All right, Ms. Abbott, I don't buy a thing you're selling me today. You know, if what you're saying is true, at the end of what I'm going to tell you, you should withdraw your plea and go to trial and get acquitted. Because if what you're telling me is true, I don't know that that's a crime. Making a mistake at your job is not a crime. I probably did it today already. You're convicted for certifying as a process server, certifying that someone was served personally when they weren't, and submitting something false to a court. That's a very serious crime. It's a terrible breach of trust. It undermines the legal system to the harm of litigants. You wouldn't like it today if I sentenced you and you weren't even here and didn't know about the case, because you're entitled to due process of law. The bare minimum of due process of law is notice and an opportunity to be heard. By your lies to a court, you deprive one of your fellow citizens of notice and an opportunity to be heard. I think that's a pretty crummy thing. You have no prior felonies, one prior misdemeanor. I don't really see a need for services on probation. It's really nothing that connects to this behavior of any like criminogenic needs, you know, that would have contributed to this situation. I certainly don't think that that kind of behavior warrants 6 months of a delayed sentence and a dismissal at the end. So again, either you're innocent and should go to trial, or if you're guilty, this would not be a just outcome. So it'd be my intention today to sentence you as follows. $68 in state cost, crime victims assessment of $130, court costs of $350, comply with DNA testing and pay a $60 fee, and serve 6 months in the Sheboygan County Jail with credit for 1 day previously served. That does not comply with that is within the advisory guidelines. I think even though it's an intermediate sanction, the circumstances of this crime, the breach of trust, and the interference with the administration of justice are inadequately taken into account in the guidelines. So therefore, that does not comply with the sentence agreement. So you've got a choice to make, and I'll give you a minute to talk with your lawyer about that. You can either accept my sentence as I've announced it today, or you can withdraw your plea, and it goes back to a pretrial posture, and we'll schedule the jury trial on 2 counts of obstruction of justice and 2 counts of evidence tampering. Yeah, if you'd like, I can pass the case, and I would just direct you to tell Miss Abbott she may not leave the second floor of this courtroom and this courthouse until we address the matter.
Yeah.
Yeah, but you can go in the hallway and talk.
Okay.
All right, and I had announced a sentence beyond the terms of a sentence agreement and given her some time to talk with you about her options. Do you know how she wishes to proceed?
Yeah, we would like to withdraw our plea at this time.
Okay, Miss Abbott, your plea will be withdrawn, bond will be continued, and we'll schedule this for a docket call for, well, let's schedule this for next Tuesday, June 9th.
That's a problem. I can let the
Yeah,
court or prosecutor know.
yeah, but don't wait for the mail. It's just next week. So I know
understand, Your Honor.
I know the mail won't get to you. So next Tuesday, July 9th at 1:30, Miss Abbott, you can appear by video as you have previously.
And there it is. Brittany Abbott walked into that courtroom expecting to walk out free. Instead, she's walking back toward a jury trial. Here's the full picture. Abbott was charged with evidence tampering a felony carrying up to 4 years for filing false proofs of service as a process server in Michigan. The sentencing guidelines allowed for 0 to 9 months, and the plea agreement called for a 6-month deferred sentence with dismissal at the end. The judge rejected the deal entirely, instead announcing 6 months in county jail plus fines totaling $608. Abbott chose to withdraw her plea rather than accept the jail sentence, meaning this case now heads to trial on 4 counts, 2 counts of obstruction of justice and 2 counts of evidence tampering. What makes this case so significant isn't just the drama in the courtroom, it's what the judge said about due process. Every single one of us, no matter who we are, is entitled to notice and an opportunity to be heard when we're hauled into court. When a process server lies about service, they don't just break a rule, they break the entire foundation of the legal system. That's not a training issue. That's not naivety. That's a choice with real consequences for real people. Will Brittany Abbott be convicted at trial? Will the story change again? We'll be watching, and so should you. If you found this case as shocking as we did, make sure to hit that like button right now. Drop your thoughts in the comments below. Do you think the judge was too harsh or completely right? And don't forget to subscribe so you never miss another jaw-dropping courtroom breakdown. We cover the cases the headlines skip. See you in the next one.